turned out to be great advice. Are you troubled by someone's drinking? You might be surprised at what you could learn in an Al-Anon family group meeting from people just like you. Call 1-888-4-AL-ANON.
Thanks for coming back to Senior Moments. I'm Patrick Samasco, an elder law attorney. And this topic today, we're talking about medical and financial power of attorney. So let's get right back into it. One question that always comes up at the different seminars is, my mom has been diagnosed with an illness. Is it too late to sign the power of attorney, whether it's medical or financial? Maybe not. Just because you have maybe a diagnosis of dementia or Alzheimer's or Parkinson's disease doesn't mean that mom can't still sign the papers. She needs to be mentally competent, which is basically know who she is, know who her family members are, know what decisions she wants her family members to make, and then make the decision of who she wants to be in charge of her actions, medical and financial actions. And so it's never too late to at least try to get it signed up. With my father-in-law, we're signing up a power of attorney for him. We had to go back 2 or 3 times to catch him at a good day. He had to have a lucid interval, is what it's called. Sometimes with dementia patients, they have really good mornings, but they get tired and it gets badder later on in the day. So you want to at least try. If you can't get it signed up, then the next topic that we'll be talking about is probate court. But let's try and focus on getting the power of attorneys. And here's the question: when do we have to have the medical and financial power of attorney signed? Does anybody know? At least a day before it's too late, right? You got to have it before it's too late. And you just don't know when that ends. So when it's fresh on your mind, it's something that you should actually look at. You can get the power of attorneys from bookstores or off the internet. Your state representatives have these forms that are fill-in-the-blank forms. If you go to the hospital, they give out a medical power of attorneys. You can fill those forms. They work fine, okay? But if I have a medical power of attorney and I don't have a financial power of attorney, what's the rule? You're going to need the financial power of attorney. So you absolutely, positively need both of them. If you don't have both, go out and get both. You absolutely.
Because my mom had a medical power of attorney done at the hospital, is that a medical power of attorney that she can keep forever? I mean, it's now a medical power of attorney for her?
Yeah, it can be. A medical power of attorney really is designed to last for her a whole entire lifetime. She picks an order. Mom picks daughter first, son second. As long as she doesn't want to change her wishes on her last illness, or if she wants to life support or no life support, that'll last for her entire lifetime. There is spots in some of the power of attorneys that you can reaffirm your decision to have no life support. So you can sign every year, yes, I don't want life support, yes, I don't want life support. Financial power of attorney is a little bit different when you're dealing with stocks and equities. If you have to have a financial power of attorney, son's going to be selling my Edison stock or my Chrysler stock or some stock, some companies want the power of attorney signed within the last 60 days. So the old ones could be problems. If it comes up, the attorney that prepared the power of attorney for you can sign a certificate of authenticity that says that he's the lawyer, that power of attorney is still valid, and that they have authority to rely on the actions of your agent. So you can't have a power of attorney signed every 60 days, right? So with that certificate, that solves some of those problems. So if you have a real old financial power of attorney, you may want to update that. Now, medical power of attorneys, has anyone heard or gone to the doctor and they have you sign the HIPAA disclosure, HIPAA? The old medical power of attorneys don't have any HIPAA language in it. And what that really means is the medical power of attorney, I picked my son to act for me when I'm incapacitated. Now, if you're in the hospital and you're not incapacitated, and your son runs down the hallway to catch the doctor, he doesn't have authority to talk to you because you're not incapacitated. That new HIPAA language says, hey, you can talk to my son if you want to. I'm giving you authority to act, even though I'm not incapacitated now. Doctor, you can talk to my son. It's really, really good language to have. People are updating them as they come into the office. We update them. Okay. Good question. With the medical power of attorney, when you have it witnessed, it's very important. The witnesses aren't allowed to be hospital employees, insurance company employees, family members. You want to be outside the family. You don't want a medical insurance company to be your witness. And I think the idea is that if you're going to be withholding life support, you don't want the medical insurance company to be the witness that says, yeah, mom doesn't want life support. You want a little bit disinterested, or life insurance. So you do want to have some type of a spot, and that's required by the law, that it has to be disinterested. Okay. Any other questions on question?
On the financial power of attorney and stuff, I'm single. I have my daughter on all of my savings accounts and things like that. Do I still need to have a trust even though she's the beneficiary plus also a co-owner of my accounts?
The question, very good question, do we need a trust agreement? But more specifically relating to this topic, if I have my daughter on all of my bank accounts, do I still need a financial power of attorney? For married couples, we know mom and dad are on the bank accounts. We know mom can sign dad's name better than dad can sign dad's name. We all know that. Do you still need a financial power of attorney? Absolutely, because co-owner allows your daughter to have access to your bank account, but she can't sell your car. Even if her name is on the car with you, it takes 2 signatures. If her name is on the house with you, husband and wife, and you're going to sell it, but dad had a stroke and he can't sign, mom can't sign his name. So if you don't have that power of attorney to sign dad's name, your husband, you have to go to probate court and get conservatorship. It's a whole extra step. Absolutely, you need a financial power of attorney, because you have insurance companies, you have pension companies, your lease on your condo, water bills, health insurance company. Those are all personal things to you that your daughter is not on those accounts. You cannot access those accounts without the power of attorney. Okay.
My dad just recently passed away, and I had power of attorney, went to the bank so that I could take care of the banking statements, but I had trouble at the bank. They wouldn't accept the power of attorney.
That's a very common question that people ask. I tried to get into the bank account. I'm on his power of attorney, but now mom passed away and I don't have access. Power of attorneys cancel upon death, always. They cancel upon death. So there's no way the bank can give the money to you or pass the money down to the children or beneficiaries under a power of attorney, because that power of attorney cancels upon death. That's why trust agreements work so great, because trusts never die. The power of attorney cancels, but the trust and the trustee's authority will continue on, and that's why trust works so great. And we're going to be talking about that in the next segment. Okay? Any other questions on medical or?
Yes. I'm a little confused about the will and between a will and a trust. If I have 2 daughters, and I have them as beneficiaries, and I also have some stepkids, which also end up beneficiaries. If I die, and I have a will, I don't have a trust. If I died, would they have any trouble going to the bank and getting the money out once they show them my death certificate?
No. There's different ways to avoid death probate, okay, and that's what we're going to be talking about in the next segment. There's ways to avoid living probate, which if you have your kids on your bank account, they have access to your account, but you still need the financial power of attorney. If you pass away, anything that's jointly owned will avoid probate, and it works fine as long as there's no problems that creep up in the future. And we'll be talking more about the specific problems that can come up with joint accounts or with trusts and how they work independently of each other. Okay, but now with the power of attorney, if you have your daughters on the accounts, they will have access to them. But sometimes the problem is they have access to the account, and if you don't trust them, or they get sued, or they go through a divorce, or there's a car accident, there's a lawsuit, their name is on your accounts, their problems becomes your problems. So you can say, I got the greatest kids in the world. They're never going to have any problems. They're in a loving relationship. They don't do drugs. They don't drink. We've been together forever. And I trust them implicitly. That's how our family is, which is great. But what happens is something terrible happens to someone really good, like they lose their job, which is happening in the community. And now all of a sudden they have to go through bankruptcy. So if they're on your bank accounts, you're going to have the risk that maybe you're going to lose those funds. So that's why joint account works great as long as everything works great. But if there's these problems, whether it's a divorce or a bankruptcy or a lawsuit, that's when your assets become at risk. Okay. Last question?
Thank you. Yes, my husband passed away just this last month.
Yeah, I'm sorry to hear.
Thank you, Pat. He had a will, but it was an old one, but it was still valid. And my daughter was the power of attorney. Now, will he have to go? This have to go into probate?
No, it shouldn't have to go, because typically with a husband and wife, everything is jointly owned. We've had cases, and we're going to be talking about that right in the next segment. So if you want to come back for the next show about estate planning and trust and how to avoid probate, we're going to use that as an example for our audience. Great. Well, thanks for coming. I hope you enjoyed. I hope you learned a little bit about, maybe a lot, maybe too much, about medical and financial power of attorneys. As time goes on, we're going to have a lot of different segments, and if you have any questions that you want to ask us, you can email us at questions@samascolaw.com, or if you want to call us, or if you have any suggestions about topics that you want to hear about in the future. The plan is to answer your questions from this show at the next show, and we're just going to go from there. So thanks for coming. I hope to see you back at the next show. Thank you.